Hello, welcome to Healthcare Law, Ethics, and Compliance. Um, I'm sure some of y'all are wondering why in the healthcare field do we have to take a law class? And that's because so much of what we do in health information management is governed by laws and regulations. So we have to be familiar with what we're required to do, all right, so that we are compliant. This first chapter, we're going to go over kind of the basics of the American legal system. Okay. Law is a system or the processes that help us deal with problems without having to resort to using force, right? So laws are the standards for behavior, how we should act. We have two types of laws, public and private. Private law is also called civil law, and that would be things between either someone, so let's say me, so me and another person, or me and a corporation or a business, or me and the government. Okay, so this would not include criminal law. We'll get to that in a second. Now, in private law, you can have either contract law or tort law. And then there's also intellectual property, which is a newer area that has to do more with patents and trademarks. So for our purposes, this would be like legal rights to software that is used to store electronic health records. Okay, but we won't get too much into that one. So contract law is just what you would think, having to do with contracts between two parties. And it can be written or an oral agreement. But in order for it to be a contract, you have to have these elements. There has to be what's called a meeting of the minds. This is when two people or two entities come together and they reach an agreement. There has to be an offer. One or both sides promise to do something or not do something. And then acceptance is the other party agreeing to that promise. And consideration. So, what does one party receive from the other party in return for whatever the contractual obligations are, what was decided on? If one of the parties does not fulfill the contract terms, it is considered a breach, and that is usually when a lawsuit comes into play. Okay, so then we have tort law. That is any other form of private law that does not involve a contract. So this could be things like medical malpractice, defamation, invasion of privacy, things like that. So there was a very famous case a couple of years ago now of tort law. That was the Johnny Depp and Amber Heard case, right? It was based almost entirely on defamation. Okay, and we already touched on intellectual property. Okay, so where private law has to do with, you as a person, me, and another person, a company, or a government, public law is between the government and a person, or the government and a business or organization, or the government and another governmental agency. Okay, a large a large section of public law is criminal law. And criminal law can be divided into two categories. So we have substantive law that defines like the specific offenses, whether it's a felony or a misdemeanor, what the liability would be, what the punishment would be. Procedural law is more of the steps through which a case passes. So starting at the investigation, the trial, sentencing, and then the eventual release of the offender. The other part of public law consists of constitutional provisions, statutes, and regulations. And these are really what govern society, like how the government and private parties are supposed to do things. Okay? So law can come from these sources here: constitutions, statutes, administrative decisions and regulations, and common law. So we're going to talk about each of these next, But because the laws having to do with health information come from all of these different sources, there's no like one document that you can look at and that shows you, okay, here's everything I need to know or everything I need to do. And so that's why we have to be familiar with all of these different forms of law. Okay, so the first source of law is constitutions, which is the fundamental law of a nation or a state that is usually written, but it doesn't have to be. And this establishes those basic principles the nation or state must follow. The most well-known being, of course, the United States Constitution. It also establishes the three branches of government. So we have the legislative, executive, and judicial. And we will talk about each of those in a minute. After the Constitution, there are 27 amendments, which just make little changes or little additions to the Constitution. The first 10 of these amendments are called the Bill of Rights. And that's the things you hear most about, right? Freedom of press, freedom of speech, freedom of religion, freedom to assemble, okay? The second source of law is statutes. So state and federal legislatures, okay, so the legislative branch I just mentioned, create laws, and they're called statutes. These have to be signed by the president if it's a federal law, or by the governor if it's a state law. A lot of times there is a conflict of law, meaning a state law and a federal law say something different on the same issue. Or even, what if two states have a different law about the same thing? So say you live in Louisiana, you go into a contract with someone, and then you move to a different state that has different laws than Louisiana. Typically, these things can be either resolved in court or, the smarter method would be to make sure it's written into that contract, if in this scenario, which state's laws will apply. Ordinances are laws that are passed at the local level by city council, so stuff like zoning laws and public safety. And then words of authority are like verbs that have legal meaning. Okay, so these like set forth duties in statutes and ordinances. So words like shall or entitled to, okay? The next source of law is administrative decisions and regulations. So administrative agencies are governmental bodies that the legislature can say to, hey, we have this issue that we need you to come up with a law about it and implement it. Okay, so these agencies are usually kind of specialized. So a healthcare administrative agency probably knows a good bit more about what goes on in a hospital. So it actually makes more sense to me, at least, that they should be the ones to write a law about healthcare instead of the people in Congress that only go to the hospital when they're sick. So administrative agencies do have to follow certain procedures. They have to give advance notice of what's about to take place. If there's anyone that is going to be affected by the change they're making, they have to be present to be able to challenge it if they want. And a public record has to be created. So an example of this would be the HIPAA privacy standards. If you've never heard of HIPAA before this class, you will hear about it a lot throughout this program. But HIPAA wanted Congress to create some privacy standards for patient health information. Okay, Congress didn't do so in the time frame that they were given. So the U.S. Department of Health and Human Services came in and said, okay, we'll do it instead. And they proposed this rule in the Federal Register, which was eventually published in the Code of Federal Regulations and is now enforced to this day. Okay, so DHHS was the administrative agency that created these regulations. Okay, these agencies have what's called quasi-judicial powers that are given to them by the legislature. They can make decisions about agency-related matters. They can provide hearings for anyone that wants to dispute their decision, and they have the power to establish an appeals process. So after all of that, if someone is still unhappy with the agency's final decision, they can request a judicial review, which would be, like a U.S. district court looking at that final decision. So here are just a few examples of federal and state regulators. I'm sure you've heard of some of them, like CMS, the Centers for Medicare and Medicaid Services. On the state side, you have all of the professional licensing boards, which is what doctors have to get licensed through, what I got licensed through, nurses, things like that. Okay, now the last source of law would be common law or judge-made law. So when there's a lawsuit, the court will hear arguments from both sides to make their decision, but in order to make the decision, the judge will look at previous court decisions. So in cases like this one, what is typically the decision? They'll look at if there are any relevant constitutional provisions or statutes and regulations. So when a court makes a decision about something that has not been decided on before, that is called setting a precedent. That precedent can then be used in future court cases involving similar issues. So this reliance on precedent is referred to as stare decisis, which is a Latin term, and it means to let the decision stand. So to use precedent, the case has to be basically the same or very similar to the one the judge is working on right then. Also, the courts are bound by whatever decision the higher court makes, meaning, trial courts have to follow the decision of appeals courts or district courts have to follow the Supreme Court decisions. Okay. In addition to stare decisis, courts are also subject to the doctrine of res judicata, which translates to a thing or matter settled by judgment. So once a court makes a final decision during a lawsuit, the guilty party can file a series of appeals to try to get the verdict changed. But if they go through all of those and the verdict is still the same, the parties can never bring that exact same matter back to court. Okay, there has to either be some sort of new evidence that's been found or something. They can't bring that exact same case to court. Okay, moving on to the branches of government. So, like I said, we have 3 branches in our government: the legislative, executive, and judicial branches. Each one has specific powers or responsibilities that they do, and they cannot do any of the other branches' powers. So this is called separation of powers, and it was made this way so that no one branch could, take over, basically. So first we have the legislative branch, which is made up of the Senate and the House of Representatives. So in the federal government, the Senate and the House of Representatives together are known as Congress. Okay. These are the people that make laws. So in the Senate and the House of Representatives, there are tons of committees that talk about bills, ideas of bills that can be passed. So they'll hold hearings and do research and all this work to try to create a bill. So say one of the committees in the House of Representatives comes up with this bill. They would then send it over to the Senate for them to look at. So the Senate receives this bill, they look at it, and they can vote to either approve the bill or they can make changes to the bill and then send it back to the House of Representatives. Okay? When the House gets it back, they have to look at it and do the same thing. They can either approve it or make changes and send it back. So they can go back and forth. I'm sure you've heard before, the House of Representatives passed this bill, and then, a few weeks later you can hear whatever bill didn't pass at the Senate. So that's what it means. Both houses have to approve the exact same bill. Okay, and then once that happens, the bill is sent to the president on the federal level, or the governor on the state level, for them to either sign or veto it. If it is signed, the bill then becomes a law. Okay? Next is the executive branch, which is who enforces and administers the law. So at the top of the executive branch would be either the president on the federal level or the governors on the state level. It also includes the vice president and the cabinet members and all of the federal agencies. And like I just mentioned, the chief executive is who either approves or vetoes bills from the legislative branch. They can also issue executive orders, and those do have the same effect of law. And healthcare providers deal most frequently with this branch, the executive branch, because healthcare organizations are subject to all the rules and regulations of agencies at both the federal and state levels. Okay, and lastly, we have the judicial branch. So this is who interprets the law. When two parties cannot figure out a dispute on their own, they file a lawsuit to ask the court to resolve it for them, right? So the court will look at all of the relevant statutes and laws and all of that and figure out, who should come out on top, who's right. So on top of all the legal requirements, a lot of healthcare organizations are also subject to like rules of ethics from different professional associations, accreditation and licensure. And also most healthcare organizations usually develop their own sets of policies and procedures and medical staff bylaws to meet their state licensing or accrediting requirements. So while these requirements aren't laws, they really affect the operations of healthcare organizations. And the organizations can be held responsible if they don't meet the requirements. Okay, so for those reasons, they're considered quasi-legal requirements. Okay, and that is all I have for you today. So now you'll be able to go back into Canvas and answer your bell ringer questions. So let me know if you have any questions, and good luck.